Okay, I'll go ahead and call this meeting to order. First item is a roll call.
Alderman Headley.
Here.
Alderman Arnold.
Here.
Alderman Schaefer.
Here.
Alderman Scully.
Here.
Alderman West. Here. Alderman Johnson.
Here.
There is a quorum present, Mayor.
Okay. Next on my agenda is public hearing to consider the revocation of conditional use permit dated December 15th, 2003. And before we get started, I have a statement I need to read since we've never done one of these before. So kind of let the board know and the audience know kind of, what the procedure is. First of all, I just want to thank everyone for coming this evening. It's nice to see that so many people are interested in the matter that we'll be taking up tonight. Before we get started, I need to explain a little bit about this hearing. This is a hearing to consider whether to revoke the conditional use permit that allows Valley Speedway to operate a racetrack. The hearing is not like a regular Board of Aldermen meeting or workshop or town hall meeting. The purpose of this hearing is to determine whether the terms of the conditional use permit or city ordinances have been violated. The proceeding tonight is a quasi-judicial proceeding in which I will preside over the hearing and the members of the Board of Aldermen will hear the evidence and make a determination about whether to revoke the conditional use permit. Because of the nature of this proceeding, I ask that everyone observe proper decorum as if they were in a courtroom. Therefore, please turn off the cell phones at this time. Do not talk or comment during the proceeding or otherwise cause a disturbance. Because this is a quasi-judicial hearing, proceeding will look similar to a court trial. We will start off proceeding by allowing the attorneys for the city and the Valley Speedway to make a brief opening statement, and then we'll move on to hearing testimony. The city will present its evidence first, and then Valley Speedway will be permitted to present evidence. At the end of the evidence, we'll permit the city and Valley Speedway to present a brief closing summation. After that portion of the hearing, we will open up the proceeding for brief public comments based upon the evidence that was presented. This means that any comments should be limited to what was presented in a portion of the hearing where evidence was presented. I want to emphasize that this hearing is not to discuss whether the track is good for the city, whether the sound levels should be increased, or whether a new conditional use permit should be issued. Those issues have been and may continue to be discussed in different forums, such as workshops, planning commission meetings, town halls, and regular Board of Aldermen meetings. The issue relevant to this proceeding is whether the terms of the conditional use permit or city ordinances have been violated, and your comments should be limited accordingly. The following conditions will apply regarding the public comment section. Only citizens and business owners of Grand Valley will be allowed to comment. Comments will be limited to 2 minutes each. Now, normally we have not been very stringent on that, but this evening we will be. And Ms. Alexa Barton will actually be holding cards up when you're speaking to let you know when you have 1 minute to go and when your time is up. Repetitive comments should be avoided. If you agree with the previous person, then come up, indicate that you agree with what they have said. And comments should be limited to the evidence presented. After receiving public comments about the evidence that was presented, the Board of Aldermen will then consider whether to revoke the conditional use permit. During that deliberation, the Board may adjourn its executive session to obtain legal advice regarding the procedure. After the executive session, the Board will reopen the public hearing and may vote on whether to revoke the conditional use permit. I'd like to introduce George Kapke, who is an attorney with Kapke and Willard in Lee Summit, who will be assisting me with the proceeding over this hearing. I'm not going to know exactly what all to do, so he's here for that. We also have a court reporter, Sharon Crawford, who will be transcribing the proceeding. All right, if we are ready now, Mr. Cook, are you ready to proceed for the city?
We are, Your Honor.
All right, you may proceed.
Mr. Moore and I, Mr. Moore's counsel for Trout, would like to offer procedurally for the record, I would offer the exhibits, city's exhibits 1 through 10 inclusive. And for the record, I want to state what they are. There's an exhibit list, so I'll just briefly go through them. Mr. Moore, why don't we just offer the exhibit list, which enumerates the exhibits? I don't need to read them.
That's fine with me.
The reporter has an exhibit list of 1 through 10, which the city is offering.
Okay.
Accept.
Okay, we'll accept the exhibit.
Mr. Mayor, on behalf of Valley Speedway, my name is William Moore. I'm the attorney for Valley Speedway this evening. From a procedural standpoint, what I'd like to do at this time in order to expedite the hearing this evening is offer into evidence the exhibits for Valley Speedway. We have exhibits number 15 through 46 inclusive, also with a list of a description of what each exhibit is, and we will offer that into evidence at this time.
Okay, we'll accept those.
Covered?
We're covered.
Mayor, members of the board, I'd like to give you just a brief overview of what the city's evidence will be and what I expect the overall evidence to be tonight. This is an interesting meeting. It's a meeting that none of you have ever, in which you've never participated, nor have I, in 38 years as city attorney here. You are all members of the Board of Aldermen, charged with making decisions on a monthly basis for this city. You have never sat in this capacity in what's called a quasi-judicial role. You are making a decision about a very important issue, you and the mayor, and that decision is different than you've ever made before. The decision you make tonight may be final, it may not. But the first step in the process, in the legal process, to determine whether or not the conditional use permit issued under which Mr. Shrout, and I'm going to probably refer to Mr. Shrout by Mr. Shrout as opposed to Valley Speedway or Impact Motorsports, which is a legal entity. You'll see Valley Speedway in the minutes and so forth, but I'll probably refer to the operator as Mr. Shrout. So you are going to be deciding the issue tonight, and that is whether or not to revoke the permit. Now, that issue is, in my opinion, very simple. It is a decision you have to make, looking at the evidence, listening to the testimony, looking at the exhibits, applying your common sense, and it's no different than any other law in this city. It is a rule, it is a regulation. This case is not about, let me say what it's not about. It's not about the city picking on Mr. Shrout. It's not about David versus Goliath. It's not about big government trying to tell people how to do things. It's not about trying to terminate somebody's business. It's not about any of those things. It is about what does the conditional use permit under which Mr. Shrout has operated and the predecessor to Mr. Shrout since 2003, it is about compliance. And it is no different, if you want to draw it down to, when you listen to the evidence, it's no different than if I were standing before a court or another tribunal saying we ought to enforce speed limits, or we ought to enforce liquor laws, or we ought to enforce business licenses. Those are all things that you and the city in different capacities are charged with doing. The difference is we've never had to do this. In the first place, there aren't many conditional use permits in the city of Greenville. Understand that the conditional use permit is kind of a different animal. It sets parameters for the operation and use of property that don't ordinarily exist, even within the zoning scheme. It says, okay, we recognize this particular use, racetrack. We're going to allow that to operate in our city. But if it operates, it's going to operate under these conditions and parameters. And those conditions are set forth in Ordinance 1619, which is the conditional use permit dated December 15th, 2003. 5 years before Mr. Shrout purchased the property. And I will take you through with Mr. Brian Hunt, who's the Assistant City Administrator and Director of Community Development. I will take you through briefly the history of how we got to where we are. This is not about surprise. This is not about Mr. Strout not knowing what he was facing when he, A, purchased the property, and B, operated the property in violation of the conditional use permit. Everybody has known from the get-go that this conditional use permit was the document, the structure under which Mr. Strout was operating. So what you will hear tonight is you will hear testimony from Mr. Hunt about what has happened. How many times has the city requested Mr. Strout to comply and provide a sound set? How many times has he said, yes, I will, and did? You will hear evidence about the 2010 sound study that the city commissioned with some engineers, and they are Cook, Flat, and Strobel. Cook, like mine, Flat, F-L-A-T, and Strobel, S-T-R-O-B-E-L. You will hear and see, it's an evidence, that sound study. You will see that sound study, which indicated that Mr. Strout was not in compliance. There are two parts of the sound study, or two locations that bear particular scrutiny, and that is how is the sound measured and from where is it measured. The ordinance requires, the zoning ordinance requires that measurement be from the property line. Now, you're going to hear testimony from Mr. Strout, from his engineer whom he hired and commissioned in May of 2014 to do a sound study. The first sound study that I think I have ever seen that Mr. Strout commissioned. The first sound study he ever commissioned after receiving notice that the board intended to consider revocation. You will hear evidence from that particular engineer about how he measured the sound, from where he measured it, and his methodology of how he did it, with which the city takes issue. And we will explain that to you through, and Mr. Moore will call his witness, I will cross-examine him. You will have to determine how to receive that evidence. You will hear evidence from your chief of police, Aaron Ambrose, about the history of compliance by Mr. Strout on providing notice of events, providing the traffic or fire lane study to both the chief and to the fire chief. And that's all the evidence you're going to hear from the city. At the conclusion of that evidence from the city, and of course after direct testimony from Mr. Hunt and the cross-examination, you are encouraged to, as the trier and finder of fact, to ask questions. And Mr. Cappy is the legal advisor for you. And there may be times tonight, I don't think many, but there may be times that there'll be objections. Mr. Moore and I have known each other for probably 35 years. We understand the nature of this proceeding. Although it is in the nature of a trial, it is as if we're in a courtroom. We will certainly conduct ourselves accordingly. It's not going to be as stringent. You're not going to see me jumping up and down making objections, although I might want to from time to time. But we're going to try to present the evidence and give you as much as you can to make a decision. I would suggest to you that when you look at the conditional use permit, as you listen to the evidence, what I would like you to do is take those conditions that Mr. Strout said he would follow. Look at those conditions. Listen to his testimony. Listen to how Mr. Hunt describes how Mr. Strout did not follow them. And I submit to you that when you do that, and when you listen to the testimony, ask yourselves, has he done what he is required to do? Has he done what you, your predecessor, 2003, probably Mr. Scully, well, you probably went on the board, and I'm not sure, I lose track. But the Board of Aldermen that approved this, said, here are the conditions. Ask yourselves as you listen to the evidence, has he done what he is required to do? Has he complied with the law, the conditional use permit, as required by every other business, every other individual in the city? And I submit that if you do, after you hear the evidence, you will move to revoke the conditional use permit. Finally, this case is not about what happens if. It's not about what happens if we revoke his permit. Or, conversely, it's not about what happens if we don't. We're not here to talk about what ifs and speculation about what happens tomorrow. This issue is before you because it has been one of those issues that has germinated, evolved, and grown into a major problem. And the problem can be resolved by you revoking the permit. I'm not going to offer any evidence on, I don't think Mr. Moore is, about what could you do, what are some alternatives, how do we compromise? There is no compromise in this proceeding. The question is whether or not you're going to revoke the conditional use permit. Pure and simple. Thank you. Mr. Hunt, are we ready for your testimony?
Are you going to give Mr. Moore an
Oh,
opportunity?
I'm sorry, he's going to reserve his opening. Is that right?
That's correct, we'll reserve.
Okay.
Are you going to have a thought?
All right, I do have,
You are.
You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do. It's coming up. It's like the next tires.
Yeah, yeah.
Mr. Mayor, may I proceed?
Yes, may I proceed?
Mr. Hunt, would you state your name for the record, please?
Ryan Hunt,
And where are you employed?
City of Greenville,
In what capacity?
the Assistant City Administrator and Director of Community Development,
And how long have you been so employed by the city of Green Valley?
approximately 5 years.
And are you familiar with the circumstances and the background and history of this particular issue involving the conditional use permit under which Mr. Shroud is operating his racetrack?
Yes, sir.
I will submit to you, sir, you heard the lawyers introduce evidence, and the exhibits list is here before you. All of these documents are in evidence. The summary of the timeline, which appears on the screen, tell the mayor and board what that is.
Yes, Mr. Mayor, members of the board, the summary of the timeline is, if we go back to 2003 and look at when the conditional use permit was initially offered and approved, this encapsulates every time that the conditional use permit came up in discussion since then, from 2003 to present day.
And why did you prepare that?
It was originally prepared for the Community Development Committee meeting last year, but we wanted to go through and freshen it up to 2014, but it's in an effort to try and demonstrate what, all the different times that we've talked about this issue and the problems that we've had with non-compliance.
All right, for the record, I told the board about the adoption of the ordinance let's start from the beginning, very briefly, with the first entry of October 8th, 2003. And first, the summary you prepared, did you take it from the minutes themselves?
Yes, sir.
This isn't something that Ryan Hunt made up?
No, sir.
All right. So let's go through the chronology very briefly. October 8, 2003, there was a request from Becky Halpin, who at the time was the owner of the property, correct?
Yes, sir.
She asked for a conditional use permit for a recreation area pay lake.
Yes, sir.
And then the next entry is December 10th of 2003, 2 months later. And I noticed that there's a request for a conditional use permit to operate a racetrack / recreation area at the old fairgrounds.
Yes, sir.
So the pay lake dropped out and the recreation area came in, or what happened?
Yeah, there's,
Actually, no mention of the Pay Lake switching to a recreation area. In the planning and zoning minutes, they reference a Pay Lake, but as it is handed to the board after the 2 public hearings with planning and zoning, then it becomes just a racetrack / recreation area.
All right. Let's move on. The conditional use permit was approved on what date?
It was December 15th, 2003.
All right. And the conditional use permit is set forth in an ordinance, correct?
yes, sir.
And the ordinance is in the record. Now, one of the things that the conditional use permit required compliance with the code and the decibel limit, correct, which is set forth in the code.
Yes, sir, in the zoning code.
And what is the zoning code decibel limit?
5 decibels.
And that was in the initial original ordinance, correct?
Yes, sir.
That was the decibel limit that was in effect during the public hearings from October of 2003 forward.
Yes, sir.
Absolutely.
That decibel limit requirement has never changed,
No, sir.
correct? For the board's edification, at the time of the adoption or approval of the conditional use permit, what was the date of the most current, then current zoning ordinance?
It was approved in 1997.
That zoning ordinance has since that time been codified in chapter 400, correct?
Yes, sir.
All right, let's go on. I want to draw your attention to August 9th of 2004, about 8 months after the initial approval of the conditional use permit. You see that?
Yes, sir.
And I note you have listed the citizen complaint about noise levels at the track. City requested racetrack provided professional sound study. Now, that was before Mr. Strout owned the property, correct?
Yes, sir.
This is before he operated the racetrack.
Yes, sir.
Who was operating the racetrack in August of 2004?
The last name was Evinger.
Chain of title, did Evinger sold it to Gilda House or sold it to Mr. Strout?
Actually, it was Halpin sold it to Gilda House. Mr. Evinger just leased the property as the racetrack.
Oh, you leased it
Yes.
from Halpin?
Yes.
Okay. So then Halpin, Gilda House, Mr. Strout.
Yes, sir.
All right, let's move on. Again, August of 2004, more complaints about the noise levels, correct?
Yes, sir.
Would it be a fair summary to say that the citizens' complaints began August of 2004 and have continued since?
Yes.
And they have basically been about sound or noise.
Yes, sir.
Those complaints have come generally in the minutes from whom?
From residents? Yes.
Residents where?
You know,
But specifically, particularly, where do they live?
It's throughout the city. I mean, there's no one particular concentrated area.
Was there, probably most of the people here, and I know the board knows, was there a particular boundary line around the racetrack which was the most egregious as far as sound, noise, access?
I know that there was several complaints from the south side of the city and from the Harris Broadway area.
Which is the north?
Yes, just to the north side of it.
Because I was reading, as we know, going through these studies, that seems to be predominantly where the problem has always been.
Yes, that is.
All right, let's continue. Let's go to the next page. Again, September of '04, comments and discussion about noise at the racetrack, correct?
Sure.
Move forward. All right, let's start focusing here. And you know these better than I, but when did Mr. Strout purchase the property?
In 2008.
Let's just focus on that. Before we go there, all of these entries from July '05 through September into June of '06, July '06, June '07, April '07, April '08, March of '09, all of those discussions in the minutes centered on problems with noise at the racetrack, correct?
Yes, sir. In fact, in March and April, there was actually discussion related to noncompliance with the conditional use permit. The operator hired an attorney or head counsel who came to a workshop, and they went line by line through those issues.
Is that when Kim Rome represented the operator?
Yes, sir.
And that was when?
That was April 4th of 2005.
And that was, again, that was before Mr. Trout was involved. He's the operator alone.
Right.
All right, let's move forward. All right, let's take a look at, now we're in September of '09, top. Alderman receiving complaints about the excessive noise in the racetrack. Discussion next workshop. March of 2010. Owner stated he's adding mufflers, installing billboards, planting trees. Citizens complaining about racetrack noise. Citizens met with staff to discuss complaints, correct?
Correct.
April 26, 2010. Mayor heard support and complaints from audience. Local business owners volunteered to perform a sound study of racetrack. Correct?
Correct.
Now, at this point, Mr. Trump is involved. He is the owner, he is the operator.
Yes, sir.
Correct? All right. May 10th of 2010, board reports, Alderman asked staff when the first racetrack sound study would be conducted. Discussion about time frame and costs. July of 2010, board reports, Alderman voiced citizen concerns about upcoming monster truck show, staff researching need for permit.
Yes,
Is that
sir.
right?
That's correct.
Do you know the first time that Mr. Trout was asked to provide a sound study to the board?
According to the record, it was 2010.
What date?
It would have been the April 26th meeting.
To your knowledge, did Mr. Trout ever submit that sound study that was promised?
No, sir, it's not in the record.
As a practical matter, and it's all I'm thinking about it, the conditional use permit requires Mr. Trout annually to conduct sound study, correct?
Yes, sir.
And the conditional use permit says he shall do it annually, or at the request, if the city requests it, for free. But he's required to do it, correct?
Yes, sir.
All right, let's move forward. Did this, by the way, after Mr. Trout said he was going to conform to the Sound Study Commission, did he do that?
No, sir.
Did the city commission Cook, Platt, and Strobel to do a sound study?
Yes, sir.
All right. Now, I'm looking at the entry under January 24, 2011. Can you pull that up? And did Mr. Trout tell the board at that time that the city's sound study mirrored his own?
Yes, sir.
Did he ever provide a copy to the board of his sound study?
No, sir, it's not in the record.
Again, in all the minutes you read, in all the years you've been here, the first sound study you ever saw commissioned by Mr. Trout was the one that was commissioned in May of 2014,
That is correct.
and that you received in June. Is that correct?
Yes, sir.
Can you tell the mayor and board the number of times, disregarding the fact that he's required to do it annually, just the number of times the city requested him to provide a sound study, and he promised to provide a sound study? How many separate times?
Since 2010, 5 times.
And he's never voluntarily, ever, to your knowledge, based on minutes, ever complied with the requirement that he provide sound study annually.
That is correct.
All right, let's go through, now before you switch, every one of these entries from August 9th of 10 through May 7th of 12, in some manner relates to problems, complaints with noise continuing, complaints continuing, failure to provide sound study continuing, correct?
Correct.
Fair statement?
Yes.
All right, let's go to the next page. Again, starting with August of 2012 through September, March of 13, May of 13, all through, what is the tenor of the discussion by the board?
It's related to sound complaints and getting that under control.
All right, now, are you aware, have you reviewed the sound study that Cook, Platt, and Strobel did?
Yes, sir.
Those results are Exhibit 7, 2010, is that correct?
Yeah.
You have that on the board?
I do not have the 2010 study on the board. I have the 2014.
You have that, it's in the...
Yes, I do have it.
record?
It's in the record.
You refer to, for purposes of the record, to what are you referring from exhibit number 7?
This is, it's page 10. It's the impact analysis, the final findings of the sound study that we had in 2010.
Mr. Cook, are you going to provide those to the alderman?
I can. It's in the record, but I can do that.
Well, they don't have it.
Well, they don't have that particular page.
Okay.
We'll make copies of it. Could you tell the board and mayor, please, the recommendation and findings of the sound study and the engineers in 2010?
The recommendation, they actually recommended several different noise abatement or buffering suggestions. This page number 10 in particular, talks about the 4 sites that are listed in the conditional use permit, the north property line, the south property line, and east and west. Of those 4 property lines, the north property line was 74 decibels was the sound reading. It was the average sound reading from that property line. And then the south property line was 66.2. And then the west was 60 and the east was 61.4.
So, based on the conclusion and recommendation of the engineers, or what was their conclusion and recommendation?
Well, their conclusion was that the racetrack was operating outside of the parameters of the conditional use permit, and they recommended different processes that Mr. Trout could go through as far as buffering the sounds, specifically trees, tree plantings, billboards, sound deadening devices, that sort of thing.
And, did you ask Rita to copy that? Has the city commissioned any other sound studies other than the 2010 study?
Yes, in 2012, the city commissioned a sound study. We got with one of the local audio, video professionals. He trained us on equipment, and so we began to go out and monitor the property lines.
And what were the results of the city's independent sound studies?
It was in excess at the property lines as well.
Now, as recently as 2012, did Mr. Shroud advise the mayor and board that there was another sound study out there somewhere that he had done?
Yes, in 2012, Mr. Shrout commissioned a sound study with the same contractor that provided our equipment.
How do you know that?
It was discussion.
Discussion in a workshop.
And I'm looking at the summary. As of September of 12, he said, I have a study, I'm going to give it to you. Did he ever do that?
No, sir.
Did you ever see it?
No, sir.
Do you know if it were ever done?
I am not certain about that.
March 25th of 13, the board requested a workshop to discuss the results of the city's sound study versus Strout's independent sound study. Strout was not prepared to discuss findings, requested an extension to mid-April. Now we're in 2013.
Yeah.
May 13th of 2013, workshop, Mr. Strout said he did have a sound study done in 2012, but couldn't find the results despite previous commitments. Is that what the minutes reflect?
Yes, sir.
The minutes reflect he had taken no additional steps to limit the sound, but suggested the mufflers were decreasing the sound by 10 decibels. Is that what it says?
Yes, sir.
And that he was committed to work with the city staff to conduct yet another study. Is that what the minutes say? Was that other study, to your knowledge, ever commissioned by Mr. Trout?
Not
Until 2014.
So, in
2012, no.
All right. So, by my count, there's never been a study commissioned by Mr. Trout that we've seen. He said there was one in 2012, but we never saw it.
Correct.
The only study we're talking about is the one done 2 months ago.
That's
By
correct.
Mr. Trout.
Yes, sir.
Have you seen any study by anybody indicating that Mr. Trout is in compliance with the decibel limit on the track?
No, sir.
Now, in addition to the sound issues, there are other restrictions set forth in the conditional use permit. Is that correct?
Yes, sir.
And they are enumerated under special conditions of Exhibit 2, correct? I'm going to very briefly go through. And Mayor and Board, I'm referring to the ordinance 1619, which you hopefully have, which is the ordinance adopting the conditional use permit. First, tell the Mayor and Board what the first condition is.
Public notice signs throughout the area of the flash flooding danger.
You know if he did that?
I
Do not know.
Have you ever seen any evidence that he
Mr. Cook?
complied?
I don't think we have.
We don't have it.
It's not that, I don't think, is it? Okay.
Have you seen any evidence that he's done?
no, sir.
Has he provided any evidence to you or any staff member indicating compliance?
Sir.
Number 2, all building construction, grandstands construction must meet design criteria. That's not an issue, is it?
The only reference that we have to that is 2005. There was a staff memo that said that they were operating under a temporary occupancy license, and that occupancy was never granted to the racetrack because of wiring problems.
Has an occupancy permit ever been granted?
No, sir.
Is there a valid occupancy permit existing today?
Not that's in the record, no, sir.
Number 3, clear fire lane, 28 feet wide, one side parking, 20 foot no parking, maintained at all times. Signs marking the fire lane must be located to meet Central Jack Fire Department regulations.
Yes,
You
sir.
see any evidence of that?
They do have signs out there.
You know when they were posted?
I do not, no.
Have you seen any evidence of when they were posted? Mr. Trotter said I posted them in 6, 7, or 8.
No, sir.
A written notice must be received by the Green Valley Police Chief and Chief of Central Jack Fire Department a minimum 7 days ahead of an event date that the estimated crowd of 100 is expected. Have you seen any evidence of compliance by Mr. Trout, other than the fire plan he filed last week?
No, sir.
So prior to the notice of revocation, prior to the institution of these proceedings, have you ever seen compliance of that requirement?
No, sir.
Number 5, a traffic, control plan, crowd control plan must be included in the notice. The chief of police must approve the traffic control plan. You seen any evidence of that, other than the traffic control plan that was submitted last week?
No, sir.
Once a year or at staff's request after a complaint, this is number 6, the operator will provide at operator's cost an outside agency to measure the noise created by events at the location that they do not exceed the noise limits of section 400.240. Correct?
Correct.
That's number 6,
Yes, sir.
sexual abuse conditions. Have you seen any evidence at any time that he complied with this requirement?
No, sir.
In all fairness, except in 2014.
Correct, yeah, the most recent submission.
After we filed, or the board filed a notice of intent to revoke,
Correct.
correct? Now, have you had an opportunity to review the sound study that was commissioned by Mr. Trout by Management Strategies Group, Inc.?
Yes, sir.
I'd like for you to direct your attention to one of the pages of that report, which is referred to as Test Site 3, dosimeter. And for the record, it is Exhibit 8. And Mayor Gordon, today is not the entire management study. Mr. Moore will introduce that. So page 6 of 9, explain to the mayor and board what that exhibit is.
This is it's a minute-by-minute capture of the sound levels during the May 17th race that they had out at the raceway.
And help the mayor and board to understand what these columns represent.
The left column, and understand I'm not an audio engineer, the left column represents a peak decibel level that occurred at that time, and the right column is what's called, it's an average of the decibels. It's LEQ. I think in this report it's actually referred to as LAEQ, but it's an averaged decibel reading that takes environmental considerations and a specific time period in mind whenever it comes up with the number.
And were these measurements taken during the time that there were races going on?
Yes.
This was taken during the Outlaw race, the Modified Lights, and the B-Mods race.
But am I to understand correctly, there are 3 separate races measured
Yes, sir.
on May 17, 2014.
Yes, sir.
And it looks like to me from a period 2016, that's 8:16 p.m.
Yes, sir.
through 21:02, correct?
902, yes, sir.
9:02, so 3 races in basically an hour,
Yes.
a little less. Of those measurements from Mr. Trout's engineer, sound engineer, you see any evidence of compliance?
No, the left column is obviously much higher, but that's not necessarily used in the measurement. The right column is the average decibel reading, and there is no indication on this page that it ever was below 65 decibels.
Now, have you reviewed the entire study of Mr. Stroud's expert commission?
Yes, all two. Yes, sir.
And are you familiar with his methodology where he averaged sound?
I think I know where he was going with it. I don't understand how he arrived at the numbers that he did. I know that he used some Federal Highway Administration guidance as well as some HUD guidance to arrive at the numbers that he had, but I couldn't begin to guess how.
And did he use an average time when there was absolutely no racing at all?
Yeah,
It appeared in the study that, and I would expect that he'll be able to go further on this, but it appeared in the study that the average number that he came up for a specific property line was averaged over the entire testing period. So those numbers seem to be artificially lower.
Staff in the city was out, I don't know, monitoring, but they were there during the measurements.
yes, sir.
Were you aware whether or not the sound was measured at this level, ground level, as opposed to an elevated level, let's say 50 feet up?
It was at ground level.
And are you aware of the difference in those two measurement heights?
I understand that there can be difference in heights, yes.
And what is that difference?
That sound can travel up and can actually increase in decibels above. You know, if you're taking a test at the ground level, it could be significantly higher above the ground, if, say, 50 feet, 100 foot in the air.
As a general summary, from the beginning of the time you worked with Mr. Stroud, and I'm sure that he's going to put on pictures and evidence of all the things he's done to keep the noise down. Have you seen any, based on the decibel readings you've seen in the studies, have you seen any appreciable decrease or reduction in that sound?
No.
And are you aware that whether or not Mr. Stroud has done the things recommended in 2010 by Cook, Platt, and Strobel?
I'm not certain about all of the recommendations. I know that there's been some trailers, some billboards. If you look at the study, it was the temporary fixes, kind of the immediate fixes, the things they could do to get the sound level down. Those have gone into effect.
Thank you, sir. Counsel, you may inquire.
Thank you. You don't mind, I'll sit and everybody can hear me. Speak into the mic, that will
assist you. Thank you for your testimony. Just a few questions I'd like to ask you. Specifically, from 2003 to June 11 of 2014, at any time during that period, you've gone through extensively all the comments that we have been elicited from the timeline regarding comments, discussions, et cetera, from members of the public at public meetings about noise. Have you ever, other than the notice of violation or revocation that was sent just recently, notified my client, Mr. Shrout, or his predecessor owner, that he was in violation, in writing?
I would say no. It's been in workshop discussion.
follow up then on the Cook Flat and Strobel study that the city commissioned. Did you ever submit a written notification to my client regarding a violation of the noise ordinance as a direct result of the sound study that the city commissioned?
In 2011, we did have a meeting with Mr. Shrout with some of the aldermen to discuss different ways that we could get the sound levels down. There was a follow-up letter sent to him that just basically confirmed the issues that we talked about and the steps that he would be taking to fix that.
Would it be fair to say that that was not a notice of violation?
Yeah, absolutely. That's fair.
Has the city of Green Valley, you talked about the occupancy permits, has the city of Green Valley issued other permits to my client for the operation of the racetrack? For example, a liquor license.
Yes, sir.
And have those licenses been annually renewed by the city of Green Valley?
Yes, sir.
Going back to the prior owner, you mentioned there was a meeting at which the owner was represented by counsel. As a result of that meeting, was the owner or his counsel advised that they were in violation and in writing, and that revocation proceedings would be commenced?
The record does not reflect.
Did you ever send a written notice to Mr. Shrout requesting or demanding that a sound study be performed?
No, sir. Again, that was all in just discussion and workshops.
As a result of the Cook, Flat, and Strobel sound study, I think you testified that you're aware that my client did do some things to try to deaden the sound, to reduce the noise level. I think you mentioned he put up some trailers and put up some billboards, which were a part of the recommendation of Cook, Flat, and Strobel, if I recall.
Yes.
Are you aware if my client also introduced, as part of the recommendation, a requirement that new types of mufflers should be utilized in all race cars that are operating on the track?
Yes, sir.
Mr. Cook went through and outlined in the conditional use permit the requirements that my client is required to follow as a part of the conditional use permit. I won't go through each of them, but with any particularity here, but with respect to the postings of signs, I think you mentioned you weren't aware whether or not he had any signs posted regarding flash flooding.
Correct.
Are you aware that he has signs up today about flash flooding?
No.
Have you never seen signs up about flash flooding?
No, not that I recall.
Have you ever notified in writing that he has not complied with the conditional use permit and installed signs for flash flooding?
No, sir. We haven't notified him in writing for these items.
With respect to the written notice that has to be received by the police chief and the chief of the Central Jackson County Fire Protection District, a minimum of 7 days ahead of an event where there's an estimated crowd of 100 expected. Have you ever notified my client in writing whether that he is in violation for not providing a written notice?
No, sir.
again, with respect to the traffic control plan and the crowd control plan, have you ever notified my client in writing that he is not in compliance with the conditional use permit?
No, sir.
Again, with respect to the requirement for annual sound studies, have you ever notified my client in writing that he is in violation for not providing a sound study?
No, sir.
So to summarize, my client, other than the notice of revocation, has never received a written notice of violation under the terms of the conditional use permit.
Correct, outside of the notice for the hearing revocation.
I want to talk briefly about the 65 decibel rating. You testified with respect to your opinion regarding the Cook-Flatten-Strobel study, and you identified in, I believe it was Exhibit 8, that there were certain weighted averages that you, in your opinion, exceed the 65 decibel rating.
Yes.
You then also testified with respect to the traffic, or to the sound study that my client provided, and opined that there were instances where it was in excess of the 65 decibel rating, correct?
Yeah, reading from the sheet, yes, sir.
Is there anything in the conditional use permit that specifies how 65 decibels level is to be measured?
No.
So the city has no basis in writing for determining how to measure a 65 decibel level.
Just as the governing authority. Because there's an absence, that doesn't mean we can't do sound studies and make that determination.
Granted, and I would submit that it would be acceptable, wouldn't you agree, that if there was another sound study done using a methodology that determined that it was not in excess of 65, that would be reasonable?
I'm sorry, I didn't understand your question.
That there are various ways to measure a 65 decibel level. We're talking about a weighted average. It doesn't even say in the conditional use permit that it's a weighted average. It says 65 decibels.
Correct.
If you were to scream real loud right now, I suspect it would exceed 65 decibels. What I'm saying is there is no specificity in the conditional use permit on how to measure the 65 decibel level.
That's correct.
With respect to the two sound studies that were done and the locations that were selected, in both instances, isn't it correct to say that the city chose the locations for the meters, the placement of the meters?
No, not in the 2014. It's my understanding that we just said it had to be on the north property line. I don't think that we had staff go out there and identify where it's going to be placed.
Isn't it correct that the placement of the sound meters were essentially the same locations that were used by Cook, Flatt, and Strobel in 2010?
Yeah, I would say close, yes, sir.
Okay. Thank you. I have no further questions.
Mr. Hunt, I'm going to address a couple of the issues. It's interesting when I listen to the questions that somehow it's now the city's responsibility to ask Mr. Trout to comply with a permit that he's supposed to comply in the first place? That's what Mr. Moore asked you. Did we ever ask him to comply?
Yes,
You understand that?
yes,
We don't have to ask him to comply, because he already said he would comply, didn't he?
correct.
And he said he would provide at least 5 different sound studies that I counted, correct?
Yes.
And have you ever heard Mr. Strout complain or question about the decibel measurement until tonight?
No,
You ever heard that?
no.
65 decibels measured at the property line. That's pretty clear, isn't it?
Yes, and let me back up. Yes, I have heard him state in the past that he doesn't think that he can comply to that.
No, I'm
If that's what you were asking,
that's
okay.
my next question. I'm talking about before he said he couldn't comply. Have you ever heard him say, wait a minute, I don't know how to measure this decibel?
No,
Or when he said, I'm gonna give you a study, well, I wrote it down when I listened to the questions, when he says, January 24, 2011, Strout stated the city's sound study mirrored his own, but never provided a copy of his sound study. He said he would get it, never did.
correct.
Did he come in and say, wait a minute, I don't like that sound study that Cook did, not me, Cook Flat, and I don't like the way they measure it, or there's another way to measure it. Did he ever complain about that until his lawyer complained about it tonight? Now, let's go to what Mr. Strout said. Have you ever heard Mr. Strout publicly state, probably right there where you're sitting, that he could not comply with the decibel rate?
Yes,
How many times have you heard him say that publicly?
probably more than 4 or 5. Yeah,
And that's in front of this board, in front of the community, the committee that was created, correct?
Stockton.
Button, maybe leaning on that control panel.
Right behind you there.
You're leaning on it, you're gonna hit it, sir.
Mr. Mayor, if I may,
Sure, go ahead.
follow-up question.
Yes.
Mr. Hunt, it was,
Mr. Cook is characterizing what I suggested and stated and asked you, it was very specific. Did you ever send a notice of violation? I didn't ask you if you ever asked him in writing to comply. A notice of violation, very technical. It's the kind of thing that municipalities often do when somebody's in violation. They send them a notice and say, you've got a period of time to cure. Did you ever send a written notice of violation saying you have X number of days to comply with the requirement?
No, stated earlier, no, we have not.
Nothing further.
And he's just had 5 years since he bought the property to comply, hasn't he?
It's correct.
And the city, any questions from the board?
Mr. Moore, you done? Okay. Okay. The board have any questions of Mr. Hott before we dismiss him?
He has been, Mayor, Mr. Strout was given a copy of the ordinance, BO 390.
It's the
the
CUP.
CUP.
Yes, sir.
So he has a copy of that on
Yes, sir.
hand. So he had those rules to know that those are what he was to follow.
Yes, sir.
Okay. I think, okay.
Any further questions from the board?
Thank you, Mr. Hunt. The city would call Chief Ambrose.
I'm good. Okay. So now, I move on. I'm good.
Chief, would you state your name for the record?
Aaron Ambrose,
And, I know where you employed,
City of Green Valley,
in what capacity?
Police Chief,
How long have you been the chief of police here in Green Valley?
12 years.
You, heard the testimony from Mr. Hunt regarding whether or not Mr. Trout has complied with the requirements of the special use, conditional use permit.
Yes.
A couple of those requirements directly involve you and the police department, is that correct?
That's correct.
And you heard me read them, I'm not gonna read them again. But I'm gonna ask you this. Prior to last Wednesday, I think that was July 1st, had Mr. Trout ever filed a traffic plan fire lanes and set forth on Exhibit 9?
Not that I recall,
Ever?
ever.
Are you aware of any compliance or written notice to you or the chief from the Central Jack Fire Department, as required in the conditional use permit, a minimum of 7 days ahead of an event date that the estimated crowd of 100 is expected?
Not that I recall.
Will you recall?
I would think so, but
You've got a pretty good memory by my.
I try.
And I asked you about the traffic control plan, crowd control plan, must be included in this notice. You ever seen anything like that?
No, again, not that I recall.
Now, you heard what I told the mayor and board. This isn't about Mr. Trout, whether he is a good guy, bad guy, or police department chasing around. It's about compliance. So for as long as you've been chief, and you've been chief not quite as long as, when did you become chief?
2002?
All right, so this was passed in 3.
Mhm.
So you've been the chief the entire time.
Mm-hmm.
Have you ever received from Mr. Trout since '08 any indication of compliance for those requirements?
For those particular requirements, not that I recall.
All right. Now, I know you're going to be asked this, Mr. Moore, wanted you to sign a letter last week, didn't you?
Mhm.
Yes?
Yes,
And let's talk about it. You were out talking to Mr. Trout about a totally unrelated issue, right?
correct.
What was that issue?
It was an issue about an upcoming event that we have some concern about.
Okay.
Not directly at Mr. Strout's property, but near.
Had nothing to do with Mr. Trout's property, correct?
Correct.
And, was it just coincidence that Mr. Moore was there?
Yes,
All right, and did, of course, the hearing has been scheduled for tonight for quite some time, is that correct?
correct.
And during the time you were there, did you talk to Mr. Moore, or did Mr. Moore ask you some questions about, Mr. Trout's compliance with the conditional use permit?
Can't remember exactly who started that conversation with regard to the conditional use permit. I believe it was actually Mr. Shrout that might have struck up that conversation part of it, and then it just kind of went from there.
All right, and did Mr. Moore, ask you if you would sign something, that is word, sign something, to the effect that what?
Yeah, we were discussing about the traffic plan, and I said, you know, if you give me something, I'll look at it, and I'll probably have no problem or issue signing that. Yes. Which is required by the CUP.
The one,
Right.
diagram, one-page diagram that I just showed you?
Correct.
Okay. Exhibit 9,
Yes.
did he ask you to sign anything, that day? Or just ask you if you would sign something that day?
I believe it was just they would give me something to look at, and I figured I wouldn't probably have too much of an issue with it. However, when I did get the email, there was a little bit more than just the traffic plan. With there was quite a bit of jargon with it. Of course, I've been in this long enough, I understand I need to also run things by legal counsel before I do sign something, and that's when I approach you with it.
And I'm not gonna introduce the letter because I won't go down that road, but suffice it to say, you did not sign a letter, the something the lawyer wanted to ask you to sign after you read what the something was.
That's correct.
Nothing further, thank you.
Chief, just a couple of questions. With respect to the specific requirements, the traffic plan, you said you've been chief for quite some time. You've been in the community, you're fully aware of the race and the racing schedule, is that correct?
Yes.
And in fact, isn't the racing schedule posted in the police department? Primarily because my client utilizes off-duty police officers to act as security guards for the racing events?
That is correct.
And isn't it true that the off-duty police officers actually sign up for these security positions on a weekly basis? Would that be a fair statement?
Yes.
That's posted in there, and they sign up for what reason?
They sign up to perform security duties off-duty as opposed to the regular work schedule to help with security for the racetrack. And they have a presence there of a Green Valley police officer, which Mr. Shrout pays for.
Isn't it also true that Mr. Shrout has utilized the police department on specific races where he knows in advance that there will be large crowds, and from time to time the department helps out with traffic control?
If the department helps out with traffic control outside of his hiring of my off-duty, I'm not aware of that, but if you're speaking specifically to the officers that are assigned there with the off-duty, I can't actually speak to that either. I've never actually seen them perform that particular duty, nor have I asked or discussed that with them.
Let me ask you a question on with respect to the racetrack itself.
Mm-hmm.
You're generally familiar with the racetrack.
Yes.
You've been out there.
Yes, sir.
And you know where the parking areas are.
Yes.
And you're aware that there are areas where no parking is permitted. Is that correct?
I've never paid attention specifically, but I imagine there probably are areas that there is no parking for the simple reason you can't park there due to.
Is it a fair statement to say that you work with Mr. Shrout on a fairly regular basis?
Yes.
Because of the racing events?
Yes.
Have you ever notified Mr. Shrout in writing that he is in violation of the conditional use permit?
No, I have not.
I have no further questions.
Chief, are you aware of any requirement in the Code of Ordinances that you are required to notify the holder of the conditional use permit who agreed to these conditions, that you're provided to give him written notice?
No, sir.
In fact, the only one required to give written notice is he, correct? The holder of the permit.
If that's what it says.
That's exactly what it says. Twice. One of them is a written notice received 7 days ahead of an event. And I'm not talking about whether your officers are out there or Joe Blow's out there as security guard. I'm talking about notice to the chief notice to the chief. That's what it says, isn't it? Not whether you know where the parking is, right?
Yes, sir.
Chief, with respect to the racing events, I think you already testified that you're fully aware of when those races occur. Is that correct?
Yes,
And you always know from week to week when those races occur.
yes.
No further questions.
Nothing on the right.
Okay. Does the board have any questions for Chief Ambrose? Okay, I have one. Chief, I'm understanding that last Thursday, July 3rd, he had a race out there. It was a special race. I just pulled that one out because I know he had that one. Did you get notice prior to that race, 7 days prior, that he was having that race?
Not 7 days prior. No, Your Honor.
Okay. That's all I have. Anyone else have anything? All right.
That concludes the presentation of the city's evidence, Your Honor. I'd suggest, Mr. Moore, you want to recess, let you reload?
Yes, if we could, we need to switch off computers so we can
Okay.
have our power.
At this time, we'll take a 10-minute recess.